In this segment, I want to explain to you exactly what ADR is and what's in what we call the ADR Toolbox. And right up front, I want to say this to you. ADR, as we use it at Commercial Dispute Management Center, is a lot more, is far more than just mediation. ADR, properly explained, includes a number of things. It includes assistance in how to negotiate. It includes how to effectively take hold of a dispute, to contain it and de-escalate it through managing people's communications and conversations to achieve that. It involves this process very early on of trying to strip down a dispute and identify very clearly what the critical issues are, and then to look at each side's perspective on each of those issues, and then lead the parties into in a cooperative way, into a progression of communication that will help them come up with creative options and solutions to each of those issues. And it includes, in the toolkit, a number of things we do, which might include sending out various types of questionnaires to help us better understand each side of the dispute and to help each side of the dispute better understand each other. To do all those types of things, use those methods, and along the way, if necessary, if we become aware that there is some difficult technical issue that's standing in the way of settlement, that's a real bugbear in the dispute. When I say a technical issue, it might be a legal issue. It might be, for instance, a technical building issue. It might be a technical IT issue, depending on the dispute. Part of what we do in triage is to identify obstacles to dispute resolution and do it as quickly as we can. So if one of those obstacles is a technical type matter, well, obviously we're not going to be able to resolve that for you. You need someone with the right qualifications and expertise. So as part of the tools in our ADR toolbox, we will use neutral experts. And we will do that early on in recognition of the fact that if we don't quickly dissipate that technical issue and remove it, it will continue to be a hindering factor and a potential roadblock in resolving the dispute. Then, of course, there's mediation. Right? And I'm saying this to you so you understand that when people talk ADR to you and they just talk mediation, they're only telling you about one tool in the toolbox. What we found again and again and again is that it's using all the tools, working through things like to do with assisted negotiation, offering conciliation, just offering skills to help people manage their communication and to have a better dialogue, and doing all those things before even talking about setting a date for mediation are extremely constructive and productive in helping early identification of issues, better understanding of both sides of the coin, both sides of the dispute, and moving people into a more effective dialogue and managed conversation, if you like, before we get to mediation. What that effectively means is that by the time we get to mediation, if in fact mediation is necessary, is that mediation really is just the opportunity to tidy up the loose ends and to lead people to drawing up a final agreement. Rather than allowing people to avoid all those other tools in the tool bag and going straight to mediation cold with none of those preliminaries attended to, and expecting mediation to be successful. We found 9 times out of 10, it's that early work leading up to mediation that ensures the success of the mediation. So mediation, of course, is an important tool, but mediation doesn't always work. In terms of dealing with people's disputes, they may need other ADR options or strategies. One could be conciliation, and conciliation is different to mediation. In that it involves someone with particular skills in the area of dispute in a more advisory role to the persons to help them work out where they stand and what they're likely position would be under the law and so on to help promote them settle early without having to leave it to a court. Arbitration is an ADR tool. But when do you use arbitration? Well, arbitration often is like a more informal way of going to court. An arbitrator is a private person that's chosen for particular skills who you take your dispute to if it can't be resolved at mediation, and you give a brief to the arbitrator. You don't need to go to court, but the arbitrator is a very skilled, qualified person in this particular area of the dispute, but he's dealing with you in a private way. You don't have to litigate. But the arbitrator's given a brief, and the brief tells the arbitrator what the first party says about the dispute and why they think they have a good case, and the other party does exactly the same thing. They give all their supporting documents and all their supporting statements, and then they say to the arbitrator, you look at this, ask us any questions you want to ask us, and we'll answer them, and then you make a determination. Question is obvious there. If you can do all this off your own bat, if you can decide who you think has the right skills and abilities and background and experience to do this for you privately, why would you want to go into a court system where you don't even know at the end of the day who's going to decide your case and how skilled that person is? All you know is it's a judge or it's a tribunal member. And like in a lottery, take your chances. Wouldn't it be better to use these effective tools that are in the ADR tool bag and exhaust them first? Make the best possible use of them first, where all the way through that there is an overriding concern by those who are assisting you to keep the costs down and to promote early resolution. Why not do that first before even considering the alternative?